So the thing to know is that this judge's decision, unless there's an interlocutory appeal, is going to be the law of the land in this case for the next 2 to 3 years, because it's going to take that much time before it gets to the Second Circuit.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
Talk a little bit about that in relationship to the decision we got on Thursday.
Right. And one of the things, Ash, that we were saying that I put in our amicus brief is I was saying that there isn't a case that the SEC or anyone can cite in 80 years that held an investment contract when the buyer had absolutely no privity, no relationship, no communication between the promoter who's selling it and the buyer. Yet they were claiming that. And so what the judge did is she did a strict Howey analysis, those factors that you just articulated. She said, okay, the SEC's basically saying these 3 types of sales all constitute securities. And so she applied that test to each sell. One sell was institutional sales. The second was programmatic, which just means Ripple sold on an exchange. And then the third type of sell was more of like a distribution where Ripple offered XRP to employees or to independent contractors, developers to build and facilitate, utility on the XRP ledger. And so she just went, let's apply those factors to each test, to each sell. And institutional sales, she said it met all the factors because they entered written contracts with Ripple. So they definitely got privity, right? There's written contracts where Ripple says,
What's privity, John?
Privity is just a relationship. In other words, there's communication of some sort. I know you buy me a car, we're in privity. If we sign a contract. And so when a person buys XRP, many of them had never heard of the company Ripple. They may have heard Ripple because XRP and Ripple was used interchangeably, but they didn't know that there was this company that sold software to banks. They just bought XRP because it was the 3rd largest crypto asset and it was cheap, as an example, right? And so there's no knowledge of Ripple in that situation. So when you talked about common enterprise, just for your viewers, you don't have to be a lawyer. Just think of this. Can you enter a common enterprise and rely on something or someone that you are oblivious to, that you're not aware that they exist? So how do you rely on the efforts of someone that you're not aware of? How are you in a common enterprise with people that you are unaware of? And so that's sort of a simplistic way to look at it. But the institutional sales, Ripple gave them contracts to sign, brochures. They talked about Ripple's business model and how Ripple was expanding and trying to enter the cross-border payment system and relationships with banks and trying to replace SWIFT. And so when those institutional buyers bought XRP from Ripple, they clearly were relying on the efforts of Ripple to build out the ecosystem, which would increase the price. There's your reasonable expectation of profits derived from the efforts of Ripple. So she said, boom, that test is satisfied. That's an unregistered security. Then when she got to Ripple selling, or the executives, doesn't matter, when they went to sell on Coinbase or Binance or BitTrue or any exchange, it's a blind bid-ask situation. So when I go on Coinbase and I'm trying to buy XRP and I see that it's 75 cents and I buy it, I don't know who I'm buying it from. Am I buying it from Rao? Am I buying it from you? Am I buying it from Ripple? Am I buying it from Coinbase because they own some? I have no idea. And so how can I rely on the efforts of those that I don't know exist? And so that's basically what she said. And she said in that type of transaction, that prong of reasonably relying on the efforts of others is not satisfied. So therefore, in the Howey case, in the Howey test, you have to meet all those factors that you articulated. If you meet 3 out of the 4 that you articulated, not good enough. right? You have to meet all. So when she said you didn't meet the prong of reasonably relying on the efforts of others, that meant Howey test is not satisfied. She didn't even have to analyze the other factors because you have to have them all. So that's what she ruled. And obviously that has huge implications for the Coinbase case. Let's just talk about that, because Coinbase is an intermediary who is just, providing a platform between a buyer and a seller in a blind situation. And that's why you saw celebration. And just so you know, you've had a lot of people come out and say, well, this result is perverse. They've used that word, dead ass wrong, whatever you want to call it, because they say it violates the whole policy behind securities laws that are meant to protect the little guy, the unsophisticated investor, not the sophisticated hedge fund. And I say hogwash to that. And I'll tell you why that I say that, because this judge isn't there. She's there to apply the law. This is what happens, Ash, when you take a 1934 Securities Act that was defining, and that all it said was investment contract, stocks, bonds, promissory notes, and then this term investment contract. And then 10 years later, the Supreme Court defines what that investment contract term means and gives us the Howey test. So we are applying 1930s and 40s law to modern day blockchain technology. When that policy was determined, we didn't have the internet, we didn't have Google. So think about the disclosures that they were talking about in the 30s. Do they equally apply to today's investor who has massive information at the tip of their hands, through the internet? And so what this judge did was apply that test. And the fact that the result seems inconsistent, well, that's for Congress to take up, right? That's for the SEC. But when the SEC engages in regulation by enforcement and just starts blindly filing these lawsuits, trying to pigeonhole and make a jurisdictional land grab for this asset class, you're going to get rulings that seem inconsistent. But what this judge did was a strict application of that test. Her job is not to say, well, let me think what they wanted to do and protect in the 30s and 40s, and then make my ruling. That would be a judge not following the law. You understand what I'm saying? And so I get what they're saying, but this judge did the right thing.
Is that Congress is immensely dysfunctional, and the challenge of getting legislation that addresses 21st century technology and 21st century legal and business issues is really a challenge.
It's very challenging. And, it is true that the Howey test is supposed to be this flexible test that can meet modern day cases. But, here's the problem. And this is why people, and I understand some of it I think is intentional and some of it's genuine, where they say, well, how can the judge find XRP in one cell as a security and not in another? That's been the law, Ash, for 80 years. In 2013, in US v. Shavers, Bitcoin was packaged and marketed, offered and sold in an investment contract. But no one claims Bitcoin is in and of itself a security. Orange groves, beavers, whiskey, chinchillas, and condos have all been packaged in a way that meets the Howey test. So the asset itself that underlines the investment contract has never been a security, unless it's a stock or bond or promissory note. That stays a security because that was named. This investment contract was this term that no one understood what Congress meant, and the Supreme Court in 1946 defined it. And so we have a judge applying a 1946 test to modern day blockchain technology. And some people don't like the result because they say that it makes no sense considering the policy implications. And I reject it. I mean, I don't reject it. I agree that they're making that point. That's a valid point, but that's not for this judge. That doesn't make her decision wrong. You understand? That's what I'm making, the point I'm making.
To what your view is the likely outcome of an appeal, if one is filed, would be.
Okay. Well, here's the thing to know, that the judge, this decision as we know, was a split decision, meaning that Ripple was found responsible for these institutional sales. But there were two executives who were also sued, and the SEC was charging them with aiding and abetting Ripple, the company, in violating Section 5 of the 1934 Security Act.
Was this Mr. Garlinghouse and Mr. Larson?
Yes. So the defendants in the case are Ripple, Brad Garlinghouse, CEO, Chris Larson, co-founder, and chairman of the board. And so the judge found that it's up for a jury to decide whether Brad Garlinghouse and Chris Larson were reckless in aiding and abetting, or whether they're not reckless. That's for the jury to decide. Regarding institutional sales, their individual sales on exchanges has been found in favor of them. The judge ruled, just like when Ripple sold on exchanges, not a security. So that jury trial has to take place first. The SEC or Ripple, they don't have an immediate right to appeal this case. Now, one of them or both of them could go to the judge and say, we're asking you, judge, for an interlocutory appeal. We don't want to do that jury trial. Will you certify that we can go up to the Second Circuit? And then the Second Circuit would have to agree to hear it. So it would require the judge to say, yes, I'll allow it, and B, the Second Circuit to accept it. So unless that happens, which I don't think it will happen, then we have to get that jury verdict first and then an appeal. And that jury verdict isn't going to take place in the next 6 months. So you're talking about a jury trial sometime next year and a decision sometime next year, and then the appellate process. So the thing to know is that this judge's decision, unless there's an interlocutory appeal, is going to be the law of the land in this case for the next 2 to 3 years, because it's going to take that much time before it gets to the Second Circuit. If Ripple could go back and change one thing in its history, this is me speculating, I would imagine that it would be not to call the XRP token the Ripple token in the very beginning, because people use Ripple and XRP on exchanges. When it was listed, sometimes it would say Ripple and then parentheses XRP. And so there's a distinction between the token, which is the native crypto asset of the XRP ledger. Just say the blockchain, like ETH is Ethereum, Bitcoin is Bitcoin network. And so Ripple is the company that sells software that's trying to replace Swift, the payment messaging and system in the world. And so Ripple is the company. And so that issue of that you were talking about is that interlocutory appeal. It is, the SEC could go and say, Judge, this is a major issue. We think you got it wrong. There's a lot of inconsistency. We're asking you to certify that this goes up. But if I'm Ripple, now here's the thing, Ash, if I represent Ripple or the executives, am I going to object to that or agree, yes, let's go get it up to the Second Circuit and possibly get a worse ruling? Or am I going to say, wait, this has been hanging over our head, these two executives, for 2.5 years. That doesn't count the 30 months that they were under investigation. So really, we're at 5 years that this has been hanging over these two executives. They have their right in court, Judge, before we go up on appeal. All you did was apply the standard test that we all agreed to. The SEC came to you and said, apply the Howey test, and you'll determine that XRP is a security. You did. They don't like the result. We shouldn't have an appeal immediately. That's what I would do. That's what I would do. And so I think that unless Ripple is going to concede and agree with the SEC that it should go up earlier, I don't see it going up earlier.